Usually when people think of discrimination within the school system, the most popular case that comes to mind is the Brown versus Board of Education, where the Supreme Court ruled segregation by race in public schools to be unconstitutional. Thus, by 1968, the integration of public schools was slowly progressing. Although public universities were now desegregated, statistically, more prestigious colleges and graduate programs remained almost all white. Thus, activists of the late 1960s protested the unbalance of racial diversity within colleges. As a result, many public and private universities created affirmative action programs, which can be described as, quote, positive discrimination. This is Alan Bakke. He's a 33-year-old white male who was a National Merit Scholarship at his high school, graduate of University of Minnesota in Stanford, with a GPA of 3.5, earning his bachelor's in engineering, who joined the Naval ROTC and continued on to the Marine Corps and served 4 years as well commanding officer in Vietnam and an engineer for NASA. And even he was rejected from UC Davis due to affirmative action. Alan Bakke applied 2 times and was both rejected. Although Bakke noticed that minority students accepted into the school were dramatically less qualified than him. Bakke eventually brought the University of California Davis Medical School to court, arguing that the school's acceptance process violated his 14th Amendment right and Title VI of the Civil Rights Act. Section 1 of the 14th Amendment states, "All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny any person within its jurisdiction the equal protection of the laws." And the Civil Rights Act states, "No person shall, on the grounds of race, color, or national origin, be excluded from participation in, be denied the benefits of, or be subjected to the discrimination under any program or activity receiving federal assistance." UC Davis countered Bakke's points, claiming that a lot of factors contributing to his rejection had to do with his personal interview his second year he applied. Also, they pointed out that many other candidates with higher scores than Bakke's had also been rejected. The Supreme Court found these statements to be irrelevant and had to question, does affirmative action, the quota system used by the University of California, oppose the 14th Amendment and Title VI of the Civil Rights Act, regarding if race should be implemented in the college acceptance process? On June 26, 1987, the court reached a split decision of 5-4. The court found that specifically the quota system practiced by UC Davis admissions did flout the 14th Amendment, although the court did allow race to be one factor along with others used by schools in their admission process. The court also required that Bakke be accepted into UC Davis. The Supreme Court claims that affirmative action would hinder rather than further attainment of genuine diversity. The Supreme Court's view has become more skeptical as the years go on, attacking affirmative action in other aspects of society such as work. For example, in Wyatt v. Jackson Board of Education, the court found that a contract that gave minority teachers more protection than white teachers from being laid off was unfair. The Supreme Court now predicts an end to affirmative action in the next generation.